Let me first introduce to you the first set of personalities and their feature. They are Attorney Ramesh Khurana, who is the Chief Attorney and Counselor at Law at the Khurana Law Firm in Gaithersburg, Maryland. His presentation here is called Business and Immigration Law Updates. The moderator here is Attorney Kenneth Haber, a practicing attorney from Boyd's, Maryland. This morning, this attorney Haber is caught in a discussion with Attorney Khurana on how H-1 petitions cannot be transferred. This is a misconception, says Attorney Khurana. Let's see.
My name's Kenneth Haber. I'm a former Assistant United States Attorney, and I'm a former Senior Attorney of the Office of Inspector General, United States Department of Health and Human Services. That's the Medicare cops. This is Ramesh Khurana, one of the most renowned, informed immigration attorneys in this whole country. He's got clients across the world, literally. And this is the Capitol Forum. Welcome, Ramesh.
Thank you so much. I like your introduction.
Well, thank you.
I
I thought it was
appreciate
a little slow to begin with. But this is the Capitol Forum.
I appreciate it. Thank you.
I thank you for being
But don't
here.
ask me difficult questions.
Well, if I don't ask you, who do I ask? How do I get my free advice?
That's true. I agree with you.
How does the viewing public get their free advice if we don't
I
ask
know.
difficult questions?
But don't prosecute me on this platform.
I won't prosecute it.
Okay.
No cross-examinations.
Yeah. Okay, go ahead.
Okay. Let's start out with something simple, like what do they mean by, and can they, transfer an H-1B visa? Is that possible or impossible?
You know, Ken, like you said, let's start with the easy one. Believe me, even some of the immigration lawyers, they use the word transferring H-1B petition when a person is already having an H-1B status and he wants to move to another employer. So this term is not only used by the employees and employers and some of the less knowledgeable attorneys as well. You know, there is no word as transferring H-1B petition, because whenever you file an H-1B petition, it goes to USCIS. Adjudication of the petition is based on the evidence which you are producing as part of the petition. So there is absolutely no question of transferring it. Of course, there are certain benefits with Go when you file the petition and when it is received under AC 21, you can start working when it is filed. But adjudication standard is never diluted, even if you are filing this petition second time or third time. It will be adjudicated based on the merit of the petition.
So it's important to fully establish the eligibility when you're filing it in the first place.
Yes,
And that goes for the second petition even.
for any subsequent petition.
So they can't just assume that because you had one granted that you're going to get the next one granted.
I always tell my clients, there is no mercy.
No mercy.
Believe me.
No mercy in the government.
No, the burden is on you to prove that this beneficiary qualifies based on this petition. And it doesn't matter that this person's petition was already approved, because they say, if you say all the facts, all the circumstances are the same as it was approved previously, they say maybe it was our error. That's it. You know that how government agencies work.
That's correct.
And if they have given any immigration benefit in error, that can be withdrawn.
Certainly can.
Yes.
That certainly can. What's your advice in regard to filing multiple H-1 petitions at the same time?
When we are talking about filing multiple petitions, it becomes very complex and confusing. At this point, you really need the services of an experienced immigration lawyer who can understand that how multiple filings can work. Like we said, let us say 221G letter is issued to a person and the person is waiting for the outcome of 221G letter. In the meantime, because this petition is already pending, because there is no final determination, you have been refused, but there is no final, because it is a kind of administrative processing. At this point of time, if another employer decides to file a petition for the person who is going through 221G situation, so that can be filed definitely. But otherwise, if we are talking about the same employer filing multiple petitions depending upon several situations, in most of the circumstances it will not be feasible. But there are certain situations when it would make sense. Let us say a petition has been filed and the employer received an RFE, request for further evidence. So, when you have to respond to the RFE request in 84 days, depending upon how much time the employer has been given to respond to the RFE, in the meantime, you want to change the employer, and another employer files the petition while response has not yet been filed or even filed, but no determination has been made. In that kind of situation, yes, another petition can be filed. And even if let us say it becomes a question of status, and when the petition is under adjudication process, it becomes a kind of bridge which will extend your status to seek extension or seek basically approval of the petition by a new employer. So, it is a very complex world.
If let's say you have a prime contractor, let's say it's Boeing, and there's IT work that has to be done, and there's a subcontractor that is seeking H-1B for somebody, and let's say that's just for namesake Boeing Sub 2. And they're having problems getting that through. Is there any reason why a different subcontractor of Boeing, say Boeing Sub 3, file an H-1B just because Boeing wants that person's skills and resources available to it, and if they're having difficulty through Boeing Sub 2, is there any reason why they couldn't have one of the other subcontractors apply for that in order to get the skills?
The answer is yes. When you are talking about Boeing Sub 3, because the petition which has been filed for Boeing Sub 2, now who is a contractor, and the ultimate placement in your scenario is with the Boeing company. So, who is the employer? Boeing Sub 2. Now, Boeing Sub 3, in your scenario, he becomes the new employer. So, this is a new employer's petition, while petition filed by Sub 2 is still pending under adjudication. It has not been decided, and the person is in good status, and the person would become in good status when petition is pending, and it is a kind of bridge, like I said. So, he continues to be in good status. Then Boeing Sub 3 will have to provide the pay stubs, current pay stubs issued to Boeing Sub 2, Boeing by Sub 2 to the beneficiaries. That will show that this person is in good status. Yes, it can be done.
That way that they can hedge their bets.
Yes, we do it all the time, Scan.
Very good, very good. Is there any particular advice when, as far as filing multiple H-1Bs that what people need to look out for or to avoid?
Yeah, sure. Now, the best thing to do is you should know that it should not cause any kind of confusion, because multiple filings would cover a very complex scenario, and especially make sure you can identify different petitions and you can see what is the outcome, and there is something which is called the last action taken by USCIS prevails. So, most of the experienced immigration lawyers, they are aware about it. So, you have to be very careful about it. So, once an experienced lawyer is taking care of it, then I think you can take care of any kind of coming problems.
I see, I see. If the employee were to get H-1B status on both petitions, does that cause any difficulty?
Again, it depends. As I said, last action prevails, whatever action has been taken by USCIS. So, you have to make sure that what is the petition approved now. I tell you, most of the time this confusion is caused when a person is in a different kind of situation. To give you an example, a person is on L1 and a different employer files a petition for him under H-1B. H-1B is approved, let us say, as from October 1. Now, he continues to work with the L1 employer because there is no project available for H-1B. And after that, even renewal of L1 becomes due, which is filed. Now, the subsequent grant of L1 petition to that particular beneficiary will cloud the approval of H-1B as from October 1. So, you have to be careful about this kind of situation. That is why I said an experienced and knowledgeable lawyer could very well evaluate the situation and put you on the right path.
And it all depends on the specific of the circumstance.
It all depends on the specifics of a particular situation.
What would be the most important thing for an individual to remember when he is filing for an H-1B petition and there's multiple employers that are interested in him?
Yeah. As I said, first of all, you should avoid multiple filings to avoid any kind of confusion, but in certain circumstances probably it's advisable. As you got an RFE for an H-1B petition, you responded to the RFE and your lawyer tells you that chances of approvals are minimum because certain issues were raised by USCIS in the RFE and he thinks that response is not appropriate to justify approval. If that is the kind of situation, then you want to jump immediately and work with some another employer who can file a different petition, because then it would be very beneficial for you. Because remember, once the petition is denied, H-1B I am talking about, you do not have any grace period. You go out of status right on that particular day when you receive the denial letter. Then you have to really go out of the country and file a new H-1B petition under consular processing and you have to return. And the major problem is for those employees who are working with consulting companies. Now, getting H-1B stamps, especially in India, has become very challenging for the employees of consulting companies.
Why is that?
You know, the reason is because of the employer-employee relationship. Now, these particular employees who are in essence the contractors, they are working at third-party locations, because a petitioner can be only that employer who is employing that person as his own employee, and he has the power to control the performance, give the raises, give the salaries, and all those factors he has to prove. And if he is working at the end client location, he has absolutely no control what that employee is doing. So, USCIS would say we are not satisfied about the employer-employee relationship, which really becomes a big issue.
Wow. These things really do get complex, and I'm glad that you're able to come here and shed some light on some very complex issues.
My pleasure, Ken.
Thank you very much.
Thank you, thank you so much.
I'd like to remind everybody, if you run into these type of issues, that first thing you need to do is get a top-notch immigration attorney to get on it before it gets more complex.
I second you. Always talk to a competent lawyer whenever you are in a situation like we have discussed.
Yes.
Thank you.
Thank you.